Mr. Chapman, just to mention a slight shift in the timetable, having seen the division of council time, we'll take the lunch break at 1:15 rather than having a sort of rather truncated start by the respondent.
My Lord, yes. Thank you.
Yeah. Yes, so, Mr. Quack, you're okay.
My Lord, thank you. I appear together with my learned junior, Mr. Mallon, for the appellants, Jomaih Power Limited and Denham Investment Limited. And my learned friends, Mr. Chapman, KC, and Mr. Allen appear for the respondent, SPV 21. My Lords, this is the appellant's appeal from an order of the Cayman Islands Court of Appeal, or KECA. That was in turn an appeal from the order of Mr. Justice Segal of the Grand Court of the Cayman Islands, and Mr. Justice Segal ordered an anti-suit injunction against the appellants in relation to proceedings commenced in Pakistan. My Lords, the issue for this appeal concerns whether the courts below should have applied the case of Henry and Geoprosco and the consequences for the anti-suit injunction had they done so. My Lords, there are three overarching submissions that I would like to make to you today. The first is that Henry and Geoprosco is part of the common law of the Cayman Islands. That's submission number one. Submission number two is that the same common law rule applies to submission to a foreign jurisdiction, whether considering that question during those foreign proceedings, in other words, in an anti-suit injunction situation, or after the foreign proceedings have ended, in other words, in enforcement proceedings. The same common law rule applies to both situations, and it would make no sense to have different tests, and there is no authority which says that there are different tests. That's the second point. The third overarching submission is that the courts below respectfully applied the wrong test. Had they correctly applied the Geoprosco test, they should, with respect, have held that there had been a submission by SPV 21 to the jurisdiction in Pakistan. Well, those are the three submissions, and if that is acceptable to the court, that's the order in which I'll make my submissions today. Yeah. So turning then to the first of my three submissions, Henry and Geoprosco is part of the common law of the Cayman Islands. My Lords, could we please start with that case? It's in the main bundle, tab 26, at page 199.
So on your three submissions, where does the point of whether they were, whether it was appropriate for them not to follow Henry and Geoprosco, where does that fit in? One?
Simply point one, is it?
Exactly, Mother. So exactly that. So the first submission is that it's part of the common law of the Cayman Islands, and therefore not to follow it was a failure to follow the common law of the Cayman Islands.
And at this stage, you've got to persuade us not only should they have followed it, but that we ought to follow it, given that it, on any view, wouldn't be binding on us.
I do. So the starting point is the case, which is in the main bundle at page 1999. This is Henry and Geoprosco. It was in 1976 in the Court of Appeal, and it was in relation to the enforcement of a Canadian judgment in this jurisdiction. The defendants said that they did not submit to the jurisdiction in Canada, and so were not bound by the judgment of the Canadian court. And they said the contract has an English law and arbitration clause. Now, in terms of the law, if we can pick this up, please, at page 2010. The Court of Appeal commenced their analysis of the case law by reference to a case called Harris and Taylor. Actually, we see reference to that starting just on the page before this. But where they get to the meat of it is on page 2010. And if I can just ask you please to go to the bottom of that page of F, and giving judgment dismissing the appeal in Harris and Taylor, Lord Justice Buckley said this. And could I please just ask your lordships to read to the bottom of that page and over the page to B. Thank you, my lord. And then, summarising then the understanding of that case, the Court of Appeal said at G, paragraph starts there, it seems to us of crucial importance when considering the ratio descendi of Harris and Taylor, and then various things, but the thing that I particularly rely on is then about 6 lines up from the bottom.
So is that right, actually, when drawing distinction between having the jurisdiction, exercising it? Does that appear from Harris and Taylor?
It does.
Where does it appear?
If it's not in the part which is quoted there, then if we look at the decision of Harris and Taylor itself, which is page within there, page 1994. My lord, there's a better reference as well. I'll find that for you if I may and come back to it.
So some of the language in Harris and Taylor seems pretty general.
It's pretty general, yeah. The point really that the Court of Appeal took from that case is that, and that's relevant to our case, is that H, back on page 2011, 6 line up from the bottom, fifthly, the defendant, having voluntarily invited the Isle of Man court by the appearance which he made to adjudicate upon his submission that jurisdiction of that court could not and should not be exercised over him, and having lost, had voluntarily submitted to the jurisdiction of that court, so that thereafter the defendant could say that the court did not have jurisdiction to adjudicate upon the entirety of the dispute between him and the plaintiff, and then this, that it would not appear from the judgments of either Miss Justice Bray or the Court of Appeal in Harris and Taylor that any of them thought that they were doing otherwise than follow a well-established line of authority in reaching the decision, which they did. Now,
but why should you be treated as having voluntarily submitted if what you've done is to turn up to argue that they don't have jurisdiction over you?
my lord, that's
It's
exactly
the opposite of voluntary submitting.
And that's exactly the point we're about to see now in Geoprosco, where the Court of Appeal make effectively the point that your lordship has just made and carve out exactly that situation. So if we're about to come to that. So what happens next in Geoprosco is that then the court set out the historical case law that they relied on. We don't need to go through all of that, save to note that it started in the 1800s. But where they then conclude on their understanding of that case law is at page 2019 at letter G. Taking this view of the decided cases which bind this court, it seems to us that they justify at least the following 3 propositions. And the one that we are particularly interested in is the third one, which is over the page. Second line over the page. The English courts will enforce the judgment of a foreign court against the defendant over whom that court has jurisdiction by its own local law, even though it does not possess such jurisdiction according to English rules of conflicts of laws, if that defendant voluntarily appears before that foreign court to invite that court in its discretion not to exercise the jurisdiction which it has under its own local law. And then the court then comes to address the point that Lord Legate, you just put to me.
So that's the relevant ratio, is it?
That's coupled with, as we now see, what is carved out, which is that a submission solely on the
test jurisdiction itself
is not enough. Yeah, exactly. So, which of course makes absolute sense for the reasons that Lord Legate has put to me. So at B, what was curiously enough, what has curiously enough never been finally and authoritatively decided, is whether a defendant appears in a foreign court, where a defendant appears in a foreign court solely to protest against the jurisdiction of that court, and such protest fails, then judgment is given against him, such appearance under protest amounts to the voluntary submission to the jurisdiction of that court. And then the Court of Appeal then say, well, there are cases going both ways. First of all, there's in re Dulles, where the court clearly thought that it would not. Then, on the other hand, the case of Boissier and Brockner equally clearly thought that an unsuccessful challenge in jurisdiction was a voluntary submission. Then, considering Harris and Taylor, the defendant went much further than protesting against the jurisdiction, claiming that he was also inviting the Isle of Man High Court not to exercise the discretionary jurisdiction, which it undoubtedly possessed under its local law to allow order for service out of jurisdiction to stand, a submission which by implication accepted that there was jurisdiction in that court which it was entitled to exercise, it thought fit to do so. And so then, at F, we do not therefore consider that adherence in the present appeal to what this court decided in Harris and Taylor compels us also to hold that an appearance solely to protest against the jurisdiction of a foreign court is a voluntary submission to that court. So, my lords, there was no finding in this case, Geoprosco, that an appearance solely to protest against the jurisdiction of the foreign court is a voluntary submission. And then we please then turn over the page to page 2021 of the bundle. We see at F a restatement of the same point just before the new paragraph. We therefore say no more than that we are not deciding that an appearance solely to protest against the jurisdiction is without more a voluntary submission. And then could I please ask your lordships to then just read from there to the top of the next page, please.
Well, as I say, it's a difficult dividing line to draw, and it's not a very satisfactory one, is it?
It's a difficult dividing line to draw, and we'll see then, particularly when we get to Mrs. Justice Carr, who considered this law, that actually the line can be drawn perfectly satisfactorily. And at the very least, that line is drawn at solely submitting for the purposes of objecting to jurisdiction is not enough. And what you don't need to do, as we'll see, is to make a submission on the merits of the case. There are some bright lines I hope to show your lordships. So then at the top of the next page, which I hope is where you've got to at 2022, there was then this argument, the one I just referred to a moment ago with Lord Hamblin. Mr. Payne, who was one of the counsels, strenuously argued that the dividing line depended upon whether there was an unequivocal voluntary submission of the merits to the foreign court. And then there's some discussion about that, which ended with a conclusion further down that page, just above G, where the court said, for our parts, we think that where any issues arise for decision at any stage of the proceedings in the foreign court, and that court is invited by the defendant as well as by the plaintiff to decide those issues, the merits are voluntarily submitted to that court for decision, so that the submission subsequently binds both parties in respect of the dispute as a whole, even if both would not have been so bound in the absence of that.
Why? Why should that be?
Because, my lord, once the parties have put an issue before the foreign court and have both asked that foreign court to adjudicate upon that issue, what the law ought not to entitle them then to do is to say, that didn't quite work in that foreign jurisdiction.
But suppose the issue is that this court isn't the right place to be arguing about this point. It's somewhere else. I don't begin to see why taking part in that argument should mean that if I lose it, I've accepted that this court is now the right place to decide the dispute.
And my lord, the reason for that is, and this goes back really to the whole premise of why one can have submitted to a jurisdiction at all. Of course, there is a doctrine of if you submit to a foreign jurisdiction, you've submitted, and where we are currently in the exercise of working out when that submission arises. But if one puts an issue in front of that foreign jurisdiction and says, we would like you to adjudicate on that issue, you have necessarily submitted that to the foreign court and shouldn't then be entitled to say, I'd like to have another go somewhere else. And that's really the whole essence of the submission to jurisdiction, that you shouldn't be entitled to have a go in one jurisdiction and then say, that didn't quite work out, I'd like to go somewhere else, please.
But it all depends what you're having a go at, though, doesn't it?
It does.
And if what you're having a go at is the question of whether we should be arguing about the substance of the dispute here or somewhere else, then it's not obvious that if you lose on that, you now have to argue the substance of the dispute here.
My lord, quite. And hence why there's that clear, bright line, which is a submission which is made solely to protest jurisdiction is not enough. Once one gets over that, then it can be. And then we'll see how the cases have determined that. But completely accept.
Well, if you're accepting my point, then the line would be that unless you've accepted that the substance of the claim should be adjudicated upon in this jurisdiction, you're entitled to. You haven't submitted.
Well, that is. I mean, that's then where there is a difference, because it is one thing to say to a foreign court, you do not have any jurisdiction to be determining this dispute. I've got various complaints, but those are all not for you. I'm not going to ask you about them. I'm not going to put them before you. They're all for the court over there. You just need to say you've got no jurisdiction. And that is different from the situation here, but also in many of the cases, where one makes that submission, you don't have jurisdiction, and, by the way, I would like you to determine this. And that's exactly what has happened in this case, as we'll come to see under my third overarching submission.
So you say that Henry and Geoprosco, and indeed the earlier case of Harris, is drawing a line between simply challenging or barely challenging the jurisdiction and challenging the jurisdiction plus something else.
My lord, yes.
And you say, even though they may still be challenging the jurisdiction, if they've added on something else for adjudication, they have voluntarily submitted to the jurisdiction.
My lord, that's exactly it. Yes.
Can I just start? Why doesn't the principle, as you gave it to us, cover the bare challenge to jurisdiction? Because you don't have to turn up to argue about jurisdiction, but you do, and you argue, the court, you don't have jurisdiction. Court decides that it has. But why doesn't the principle that you've articulated not prove too much? Because it would cover that case as well.
Well, if I've understood that question correctly, the The point that comes out of the cases and that I'm bringing to your Lord's attention as a matter of the common law, at least as it stands, is that there's that dividing line between just doing the first thing and not the second.
But you're having another go in both cases.
You sort, as I understood it, you clearly identified there is this dividing line. I followed that, but then you sought to give us the underlying principle that's justified why there would be a submission to the jurisdiction in other cases. My question is directed to, well, doesn't the principle that you've articulated not cover the objection to the jurisdiction case as well, and therefore prove too much?
Well, there is a difference between between just saying to a foreign court you have no jurisdiction and preserving that argument. So by objecting to jurisdiction, one hasn't overstepped the mark in terms of arguing the case in any sense or anything like that. I mean, you're simply saying it should be over there.
But you don't have to appear at all, and the court can just make up its mind assisted by one party.
Yes.
But you don't want to leave the court in that position. You want to put your submissions to the court. You, court, do not have jurisdiction in my case. So in that sense, you have put your arguments before the court, and it's ruled on them. It says...
I understand. But in which case, and this goes back really to the point that, that Lord Leggett was putting to me, which is there has to be a policy decision, which is what, and that's where the cases have drawn that line, which is if you simply say to a court, with respect, you don't have jurisdiction, it should be over there, that shouldn't mean that you are submitting to that jurisdiction. That's the clear, bright line, solely submitting to the court. But there is a difference if you are then arguing the case, and that's with respect, I submit the effect of the authorities is, and that's
when you say arguing the case, you mean talking about the merits, or
not necessarily. I mean, let's say if one in a stay, and we'll see this again on the authorities, in a stay application. You see, in this case, in a stay application, we want you to stay the application, and whilst you're doing that, we'd like you to vary the injunction so that you order us to be entitled to do something. That is different to an argument in relation to the substantive merits of the case, but it's an issue that one has put before that foreign court.
What about a pure stay application? Where do you stand on that? Suppose you just apply for a stay in favour of arbitration. Suppose you've got an arbitration agreement, you're sued in the foreign case, the court, and you turn up to say that they've agreed to arbitrate, please stay in favour of arbitration. Have you submitted then?
No, because that's purely on the grounds of jurisdiction.
Well, why not in your case? Because you've had to accept the court's jurisdiction in order to argue that it shouldn't exercise that jurisdiction, it should stay the proceedings instead.
Because, my lord, it's simply all based on the court not having jurisdiction. You're simply saying to the court, you do not have jurisdiction, you should stay.
But you do have jurisdiction in the arbitration cases.
Yes.
It simply has been agreed that you'll arbitrate it rather than...
And you are actually exercising your jurisdiction as a court when you stay, because you're saying, in respect of our proceedings, we will order a stay.
Yes, although there is a conceptual difference between dealing with issues that are in dispute between the parties and where the case should be heard from a procedural jurisdictional point of view. The stay application that we're talking about at the minute can only go to the second of those. I of course appreciate that a stay application and the order that's then made by a court is effectively an exercise of that court's jurisdiction to say you can't be here, you should be in arbitration. Of course, I understand that. But there is a conceptual difference between that and the issues in dispute between the parties.
What about forum conveniens then? What's your position on that? Suppose you turn up to argue forum non-conveniens. Are you submitting or not?
No, my lord. Again, that's simply an objection in terms of jurisdiction.
So does Henry and Geoprosco turn on the fact that it was a Scott and Avery clause in that case?
That's exactly it, my lord. And so that's what we then see.
So insofar as Henry Geoprosco is saying that an argument about whether a jurisdiction should be exercised as a form of convenience, insofar as it's saying that's a submission, you're saying it's wrong, are you? Proposition 3 we're looking at.
In Proposition 3 of Geoprosco, well, no, I don't say it's wrong. The Proposition 3 is qualified by what the court goes on to say in the next, so we're at the top of page 2020, Proposition 3.
That is talking about a forum convenience argument, which was the point in the Henry and Geoprosco case.
Well, it is, but then, as I say, what immediately afterwards, the court goes on to say, but carved out of that is, if you solely protest against jurisdiction, that won't find...
You're saying a forum convenience argument is solely protesting jurisdiction?
My Lord, yes.
Right, well, I think...
Of course, it may that in the ordinary case, as we'll see here when we come to the application that's made here, parties may ask for various other things. In this case, the party in Henry and Geoprosco, the parties were asking for the defendant party was asking for a declaration that it was a Scott and Avery clause that went beyond simply saying you don't have jurisdiction, you should send this somewhere else. It said instead, number one, there is which effectively Scott and Avery clause, there's a condition precedent to this court having being able to do anything, and you should say that the parties have to go and arbitrate before that can happen. Well,
and so that, you say, makes all the difference whether you have that clause or whether you're simply staying in favour of arbitration.
In that case, that's exactly it, and we'll see that that's how the court reached their conclusion. But of course, in different circumstances, there may be different things. Our case is not, it's nothing to do with Scott and Avery clauses, but that we will see that it was a stay application, and then Pakistan court, please order that we're entitled to do X, Y, and Z. We'll see that when we get there. Well, where we were is at 2022. At G, which was just, so this is on the point about whether what's required is a submission of the substantive merits, which was argued by Mr. Payne, and then the court said, we do not agree with that. If you put forward an issue, then that issue is being voluntarily submitted. And my Lord, that discloses what from Henry and Geoprosco, as a matter of the common law of England, that where the dividing line stood, namely the dividing line is what is and is not, the dividing line as to what is or is not permissible is not whether the substantive merits of the underlying case have been put forward, whether that's in a defence or anything else, but whether the parties have invited the foreign court to decide an issue in the proceedings, and which goes beyond simply objecting to the foreign court's jurisdiction. And the reason why that was of relevance in this case is explained over the page, top of page 2023. This is a particular relevance in the present case, having regard to the application for stay, coupled with the submission that the arbitration clause was a Scott and Avery clause. And if I could ask you, Lordship, just to read, if you already haven't, down to C there, please. My Lords, I respectfully submit that that is correct.
But do you say they're wrong when they go on to say that... Oh, I see. They're just saying the application for stay was clearly a voluntary submission. You say that depends on it having the Scott and Avery clause.
In that case, exactly. It needs to be objection to jurisdiction plus. Simply an objection to jurisdiction is enough. And the point the court was making was, it doesn't make a difference if you're putting forward an issue to be decided by the foreign court, that's raised in the course of an application for a stay. which is effectively what happens in this case as well, although we'll see there's something extra beyond that as well on our facts.
Can I just ask you about this Scott and Avery argument? Because at the moment I'm slightly puzzled, because you would have thought that that is an issue that solely goes to jurisdiction as to whether there's arbitration or before the courts. That's the only relevance of deciding whether it's a Scott and Avery clause, as I understand it. So why isn't that purely a challenge to jurisdiction, just as you've told us that forum non conveniens is ultimately only really concerned with whether there's jurisdiction or not? I'm struggling to understand the distinction, I suppose, between the Scott and Avery and the forum non conveniens.
My Lord, I understand that. The Scott and Avery clause point is something that, at least in my experience, does not arise in modern day cases. There are effectively no arbitration clauses these days that include a Scott and Avery clause. There's probably some in it somewhere, but one doesn't come across them these days at all. My understanding is that kind of clause was put forward as a condition precedent. So it wasn't it may have been a jurisdictional argument as well, but it was also put forward as a contractual promise, a condition precedent, and in that sense was therefore going beyond simply saying, I object to the court having jurisdiction.
Well, it says you've got no cause of action yet, because there's been no award.
Correct. And I think of course, the exact basis on which the court here says, well, the Scott and Avery clause gets us over the edge is only going to be important really for that case. The principle that I'm seeking to draw from this case is there is a bright line at simply objecting to jurisdiction isn't enough. You need something else, and I'll come on in a moment to look at what that something else is, and what that means, and we've got Mrs. Justice Carr, who's got some very helpful guidance for us on that, and then show you what I say on this case amounts to that something else, which takes them over the line and amounted to a voluntary submission in Pakistan.
I'm still struggling slightly, because the only importance of the condition precedent is actually to go to the answer to the jurisdiction question. So it's hard to see it has any other relevance. Conceptually, it may be a bit more tangled than just saying, well, there's no jurisdiction. You have to actually sort of interpret the contract and decide whether there's a condition precedent. But the only
might have to interpret it, decide whether you've agreed to promised exclusively to arbitrate. It all depends on the contract, doesn't it?
And of course, what you might do, my lord, is you might, let's say there's no dispute about jurisdiction. Whatever the position, it's all governed by English law, and if there was to be any court proceedings, it has to be in England, no question over jurisdiction. But there would be an argument, or maybe an argument, as to whether the parties have contractually agreed to do something else first. That wouldn't be a jurisdictional question. It would be as my Lord Hamblin puts it, there's no cause of action until one has complied with that condition precedent.
But it is a jurisdictional question, you say, if they've agreed that any dispute must be resolved by arbitration. Full stop.
My lord, yes. That's a purely jurisdictional question, and that submission by itself, or that application by itself, wouldn't give rise to a...
Right. But take Lord Legate's example, that it's not a Scott and Avery clause, but it's a clause the interpretation of which is debatable. Does it cover these disputes or not cover? And you're the defendant saying that the dispute is covered and there should be arbitration. You appear to say to the court, this is covered by an arbitration clause. The court has to interpret the arbitration clause to see if that's right. And if it is right, it would stay, but if it's wrong, it would proceed. Is that a submission to the jurisdiction?
My lord, no. Of course, what the court would be engaged in is what most courts of the states courts of the parties to the New York Convention will be doing, which is simply saying, if there's an arbitration clause, then I'm obliged to stay the proceedings. That test is at a reasonably high level of generality. In many cases, is there an arbitration clause that might bind here? But to the extent it needs more of an investigation, my submission would be that that's not a submission to the jurisdiction.
Right, but it would fall within the sort of the rationale principle that you mentioned at the outset, in that you have turned up to this court armed with your arguments, and if you lose those arguments, as I understood what you were saying, and it seems to reflect some of the dicta in Geoprosco, you should be bound by the decision of the court on losing those arguments.
Well, yes, but save where those arguments only go to question of if you're solely protesting jurisdiction. So in the position that your lordship put to me, as I understand it, all of those points are being put to the court to say you do not have jurisdiction. Every single point. There's nothing beyond that which is sought, and therefore it's all solely to protest jurisdiction.
Yes, all right.
I of course accept that there are going to be cases that are on the dividing line, and that one has to, whatever the test, whether the test is the 1982 Civil Jurisdiction and Judgments Act, or whether it's a common law test, and whether it's the Williams and Glinsbank test that my learned friend says should apply, we'll look at that, or whether it's the test that I put forward. Of course, there are always going to be questions about on which side of the line one falls, and some situations will be more difficult than others. Probably the examples that your lordships have been putting to me are close to the line where they're difficult examples. But
you say that taking a forum non-convenience argument is protesting a jurisdiction.
My lord, so long as it's purely about this, you foreign court do not have jurisdiction.
Well, it isn't.
No, it isn't.
Where that jurisdiction should be exercised. Whether it should be exercised or not.
The starting point is that it does have jurisdiction. There's two places that do, and the question is which is the more suitable.
Well, Lord, I take that point. I understand that. In a question of forum non-convenience, it strikes me that in most cases, what's being said to that foreign court is that I am protesting against your jurisdiction. Now, it may be being done by way of there are arguments as to why this is not the appropriate court, but surely that's all aimed at protesting that court's jurisdiction rather than anything else.
Well, I'm inclined to agree, but I think Henry Geoprosco says something different.
Well, I think well, of course, that's a 1976 case where 50 years on we see a little bit of development of this over the time. But so far as the
That's a dangerous argument for him, Mr. Quirk.
Well, it is up to a point with that. I mean, the point is that what the courts in both the Court of Appeal and the first instance judges here had, and the first instance judge can't be criticised because his argument wasn't before him, but what they didn't do was apply the common law test that relates to submission to the jurisdiction. Now, I submit that test is Henry and Geoprosco, but it actually doesn't matter if it's the alternative test that my learned friend puts forward on the case called Williams and Glinsbank, which was developed on a sort of twin track, no doubt what we've got here. Doesn't really matter, whichever way one looks at it, but it appears to us that a better analysis based on how the law has developed, given that this principle has origins in the 1800s and Williams and Glinsbank is a much more recent one, that this is
When you say the common law test in Henry and Geoprosco, what exactly do you mean? Are you talking about Proposition 3 or something else?
Well, Proposition 3, but as explained in Geoprosco. So, namely, that one, if you solely protest against jurisdiction, that's not enough. Number two, what you're not looking for is a submission on the substantive merits. You don't need that. And number three, a stay application may well find you on the wrong side of the line when looked in the round, and in particular, where you've argued something other than you don't have jurisdiction. We'll see a few examples. My lords, on that basis, the court in Henry and Geoprosco held that the defendant had submitted to the jurisdiction of the Alberta court, and Geoprosco therefore represented the common law in England prior to the Civil Jurisdiction and Judgments Act 1982. And I respectfully submit that there can't be any doubt about that, not least because there are various indications that the 1982 Act was designed to clarify.
Can I just ask you one question before you leave, Geoprosco? On 2023, you took us the paragraph at the top of the page based on the Scott and Avery clause and how they say that they've submitted through that. And then the first sentence of the second paragraph. And then they go on to say, but we're also of the clear opinion that the application to set aside the order for service out on the second and third grounds mentioned was equally a request not to exercise jurisdiction. Can you just help with what those second and third grounds were, which they're also saying amount to a submission?
My Lord, yes. I'll just.
Does that seem to go beyond the Scott and Avery point?
It does. There were other bases on which that was sought, and well, can I come back to?
Yes, it'd be helpful if you came back and told us A, what they were, and B, whether you say they're correct or not correct.
Yeah, of course. I'll just get the reference and then come back to you on that. Thank you. So in terms of Geoprosco representing the common law in England prior to the 1982 Act, I'll just show you, if I may, two cases. The first is Trackermin, which is at tab 42 of the main bundle, page 2502. This was a case in 1983. But applying the common law, I think, well, I don't think we're entirely sure, but I think on the basis that the events preceded the 1982 Act, albeit then the court, what happens during the case is that the 1982 Act comes into force and therefore the court then applies that. We'll see that in a moment. So here the contract provided for arbitration in London. The buyers commenced proceedings in Switzerland. The sellers requested a stay in Switzerland based on the arbitration clause, and then the buyers sought what was effectively an anti-suit injunction in this jurisdiction to stop the arbitration, given that they said the sellers have submitted to Swiss jurisdiction. And the buyer's application was refused on the basis that there had been no submission to jurisdiction under Section 33 of the 1982 Act, but would have been before that, based on the common law as per Geoprosco. My Lords, if we pick this up, please, at page 2509, letter D.
Can you just get on the question of Geoprosco?
Yes.
The third ground was forum convenience. You see that at 2005 at C to D.
Lord, yes, thank you. Second was the plaintiff's affidavit seeking leave to serve out of the jurisdiction was defective. Third was Supreme Court was not the forum. Thank you. So back in Trackermin at page 2509, the D, having referred to law on what amounts to submission.
So Mr. Justice Staunton takes a broader view of Geoprosco than you do, because he seems to think it applies to just a general stay application, not just a Scott and Avery clause.
And my Lord, he's not the only one. The reason that we've seen various criticism of Geoprosco over the years, and it was actually on the basis that of that, it must decide that simply protesting jurisdiction is sufficient, but it did not. And we see that in some other jurisdictions as well, but properly understood, in fact, just simply on a plain reading of it, it doesn't. That was never the intention of the Court of Appeal, and I think because exactly the reason that Your Lordship...
Well, I don't think it's as clear as you say, I must say, because on one reading, what they're distinguishing is the situation where all you say is you don't have jurisdiction. and they're distinguishing that from a situation where you're assuming jurisdiction in order to argue that they shouldn't exercise it, but instead should stay the proceedings.
Well, we'll see. Perhaps because we're going to see a few more cases, and we'll see how it's also being interpreted, including by Mr. Justice Carr. But certainly here, I absolutely agree that that's how the court interpreted it here. But in any event, the point I'm just perhaps going to here is just more to say, as at 1981, the Henry and Geoprosco was the common law, and then following the Act, as we see at H, the effect of Section 32(1), that's of the 1982 Act, is as they say there. If Henry's case had still prevailed, I would have held they had done so, i.e. submitted. The point is now dealt with in Section 33, and then over the page, top of 4 and 2, that subsection might have been tailor-made for this case. The sellers must accordingly not be regarded as having submitted to the jurisdiction of the Swiss court. So that was 1983, just as the Act was coming into effect. If we show you one other case to make this point good, namely that it was the common law, page 1967.
When you say it was the common law, you mean it was binding on Mr. Justice Staunton in England, because it was a decision of the Court of Appeal.
Correct. Correct.
Non sequitur that it's binding on the Privy Council on an appeal from Cayman Islands.
Of course, I understand. Of course, I appreciate that. Yeah. It was the point I'm dealing with at the minute is that this was the common law of England and Wales. The next point I'm about to come to is, as a result, it was the common law of Cayman, and I'll show you why I say that in a moment. So the next point, just to make that good, is Golden Endurance, page 1967. This is a judgment of Mr. Justice Phillips, as he then was, in 2016, and it was in relation to recognition of a Moroccan judgment by the English court. And page 1975. If I could actually please just to read paragraphs 28 to 30, which just makes that point.
Again, that looks like a wider interpretation of Henry and Geoprosco than yours.
Yes, unless, I don't know if you got to J, my lord, letter J. The court left open the question whether an appearance solely to protest against the jurisdiction of the foreign court would be a voluntary submission to that court, which is the bright line that I've been.
But the earlier part isn't tied into Scott and Avery.
No. I certainly don't suggest that Scott and Avery has anything to do with the test whatsoever. It's that that was simply an example of, in that case, it's objecting to jurisdiction plus something else. So my lords, again, Mr. Justice Phillips making the point that Henry and Geoprosco was the common law of England and Wales until it was reversed by statute in the form of Section 33 of the 1982 Act. Now, my lords, there has not been any equivalent to Section 33 of the 1982 Act in Cayman Islands. And so, I submit, the common law rule in Geoprosco remains the law of the Cayman Islands. My lords, that is supported by an analysis in an English case by Mrs. Justice Carr, as she then was. That's the case of Strategic Technologies, which is at page 2365.
Just before we go there, if one turns over the page just to have a look at section 33, so this is 1976. What's your submission in relation to 1A and 1B? So what the Act is saying is that if you just contest the jurisdiction of the court or ask the court to dismiss or stay the proceedings, grounds of arbitration or somewhere else, that isn't going to count as a voluntary submission. Now, as I understand it, you would say that was the law in any event.
Correct, my Lord, I would. Yes.
So A and B haven't changed anything. Is that right?
My Lord, that's correct, save for there's just perhaps just a little tweak to B, which is that to the extent this is saying anything different, that a stay may amount to a submission if you're asking for something else within it. But I think that must be implicit within
That's your Scott and Avery.
or whatever it is. Yeah, I don't want to get too fixated on Scott and Avery.
Yeah. Okay, but that's an example of it. Yeah. Okay.
But my Lord, yes,
Okay.
this was.
So it looks as if we're getting a bit of a picture here that people have just not been interpreting Henry and Geoprosco as in quite the same way as you, because they clearly have taken the view that the statute has changed Henry and Geoprosco. But I think you're indicating that it's a pretty marginal change.
Lord, I think that's right. I think it is a marginal change. It was done in order, I think, to clarify what was a confusion on the cases, and we've seen a little bit of it just in the two cases I've shown you, which is some courts considering that actually what it had decided was you object to jurisdiction, that's good enough, and others saying, hang on, that's not what the Court of Appeal said. And I think that's exactly why the clarification came about. But what we then see in which I hope is a little bit of further light on this, is from Mrs. Justice Carr at 2365 of the main bundle. I'll keep referring to her as Mrs. Justice Carr. I think that's the right thing to do when we're talking about her decision, but of course, I don't want to get myself in trouble.
Certainly lengthens the submission if you have to. So yeah.
This was a case regarding registration of a Cayman judgment in England, which itself enforced a Singaporean judgment. And so the question was whether there had been submission to the jurisdiction of the Singapore court as a matter of Cayman law. Well, necessarily what that means is this is not a Cayman court decision, but it is, I submit, an authoritative assessment of the law.
I find that very hard to accept. It's a question of, on a question of foreign law, isn't it? It's a matter of fact in the English court.
Well, it is.
It'd be like you citing, if we were sitting in the Supreme Court here, an Australian case on what they thought English law was, what should be decided at first instance in England, and saying that's a powerful authority.
Look, I'm not, to be very clear, for that exact reason, I am not relying on this as this is a statement of Cayman law. I am, though, relying on it as a further indication of Henry and Geoprosco was the common law in this jurisdiction, and that absent good reason, under the normal rules in Cayman, that is the law of Cayman, and that an English judge, having heard full argument and heard expert evidence on Cayman law, came to that conclusion. But that's as far as I put it, for exactly the reason that your Lordship has put it.
Okay.
So if we then please go within here to page 2390, which is the analysis, and paragraph 101. If I could just ask your Lordships, please, just to read paragraph 101. There's a bit of citation from cases you've already seen, so you'll be able to look over that. Thank you. Paragraph 10. So the 3 points that really come from that are, according to the experts, in that case at least, Cayman Grand Court will follow English law unless there's a good reason not to. 2, that Geoprosco was an authoritative statement of the common law position in England, and 3, whilst it was negatived by the CJJA, the 1982 Act, there's no statutory equivalent in Cayman. And then
The question she asked herself, for better or worse, was whether a first instance court in Cayman would follow Geoprosco, wasn't it? Grand Court.
Yes.
I think it's usually said that if you're going to ask what the foreign court would decide, you ought to ask what the highest foreign court would decide. And if she'd asked herself what the Privy Council would decide, she might have come to a different answer.
Well, her ladyship was looking at, I can't really answer that question, but her ladyship was looking at what the common law was as she saw it. Of course, I of course can't. This court can declare the law as it wants to declare the law, but in my submission, an analysis of what the common law is, and therefore all things being equal, it would apply common law of England, and therefore all things being equal, it would apply in Cayman, is a good starting point, and absent a good reason ought to be a good ending point as well. And so the analysis of looking how the law developed is not a bad one. In fact, it's the one that this court would still engage in. There may, I accept, of course, be a further part of the analysis in this court, which is, well, actually, is that what we think it should be? Now, at 102, the judge said, if this was a question of English common law, it would be clear the court was bound to follow Henry and Geoprosco and conclude that MND submitted to the jurisdiction of the Singapore court without more by virtue of its application to stay the proceedings. That stay application, which we see at paragraph 11, if you'd like to look at it, was a stay application coupled with something else, namely extension of time. And then at 103 to 104, the judge said that it was argued here that there was a requirement for an additional requirement on the Geoprosco test, namely that there was a requirement for a contest of the substantive merits. So when the judge said that 2 cases would be considered, Banco Mercantile and Masri, what was being submitted was there was an additional gloss on Henry and Geoprosco in Cayman, namely you need an argument on the merits. And Mrs. Justice Carr said, I do not accept. She said, however, halfway through 103, it's striking that Henry and Geoprosco is not referred to in either of those cases, and I do not accept that Henry and Geoprosco can or would simply be disregarded. In other words, I do rely on that sentence as a general principle. That must be right, that whilst common law does, of course, develop, one doesn't just ignore the decision of the Court of Appeal, which itself was based on a line of authority going back to the 1800s. And so at 104, the judge said that she finds the effect of those judgments is not to have introduced such an additional requirement. There is under Cayman law no separate prerequisite that a defendant should have substantively contested the substantive merits in a foreign jurisdiction before it will be found as a matter of Cayman law to have submitted to that foreign jurisdiction. I submit that's in accordance with Henry and Geoprosco and makes sense. And then further down 104, penultimate sentence, it would be hard to see how the imposition of a requirement for a contest of the substantive merits in order for submission to a jurisdiction established could be anything other than a grand departure from English law. Then at 105, in light of the evidence I've heard, I find that Cayman law requires the court to look objectively at all the circumstances in the round to determine whether there's been a submission to the jurisdiction of the foreign court. Such a submission can take place without a full contest on the merits.
It tells you what you don't need, it doesn't actually tell you what you do need.
Well, my Lord, I submit that that's against the analysis, of course, that she's just gone through, which is you don't need to have a contest on the substantive merits. A simple objection to the jurisdiction itself won't be sufficient, but of course one looks at the matter in the round, and I submit that's...
Well, probably one should always look at the matter in the round and all the circumstances, but that's a meaningless proposition.
I understand that. And then at 106, as a result, she said, adopting that approach, I'm quite satisfied that the MND submitted to the jurisdiction of the Football Court as a matter of Cayman law. And then she sets out the reasons for that, including that not only was there a stay, but that stay application asked for various things. We see it subparagraph 3 on page 2392, for example, Roman 3, that the stay was coupled with an application for an extension of time and also discharge of the injunction and an inquiry into damages. That was it wasn't just a stay, it was on jurisdictional grounds, it was stay plus.
Going back to my lord's point, what do you say positively when you're looking at matters in the round you're looking for? What positively do you say amounts to a submission?
Well, on the facts of this case, what I say amounts to submission is that where one makes an application to stay to the foreign court, but says to the foreign court, we would like you to allow us to appoint the following directors to the underlying company, which is because that would have given them what they wanted in the case, frankly. And they were...
So if you were formulating it as a matter of principle, moving away from the facts, how would you formulate?
So my submission, it's those three points. So number one, there cannot be a submission to a foreign jurisdiction where that is solely a protest to the foreign court's jurisdiction. Number two, that there is no requirement that the substantive merits have been put before the foreign court. Number three, that a stay application may be sufficient if what is sought in there goes beyond simply a contest on the jurisdiction.
Right.
So what is the principle, to answer Lord Salisbury, what are we looking to, what causes you to be bound by the foreign court's determination?
So, well, my lord, so on the third of my 3 points, but I think, my lord, it's quite difficult to give an exhaustive set of circumstances where that could arise. But on the facts of the case before Mrs. Justice Carr seeking a stay.
No, sorry, I wasn't asking you to explain how the principle applies, but I was asking you to explain its rationale.
Its rationale?
Yes. What is it that justifies treating you as bound by... why are you treated as bound by the court's determination of the merits?
Yes, my lord.
Even though you haven't agreed, and in fact you've been arguing that the court should not determine the merits.
Because, my lord, and that's what's happened here, whilst you have said you should stay your proceedings, you have also said to that foreign court, and we'd like you to determine this. And once one puts an issue that is not solely an issue of jurisdiction before the foreign court, one is accepting that that foreign court has the jurisdiction to determine that issue, and that is a submission to that foreign court's jurisdiction. And if it was not, and it's got complete rationale, if that was not the case, we would be in a position that would cut across the overriding principle of that we're concerned with here, which is you ought not to be entitled to put an issue before a foreign court and then say, if you don't like the result, I'll pursue it somewhere else.
The judge found that they hadn't done anything more than challenge the jurisdiction.
I'm so sorry.
The judge found that they hadn't done anything more than challenge the jurisdiction
In
this case.
well, the things that if one looks at para 107,
I'm looking at our case.
Oh, sorry. I'm sorry. I thought we were talking about the. Sorry.
That's right. The judge found that they hadn't done anything more than challenge the jurisdiction.
No, but that's we'll look at that under my third submission. That's because what the judge was looking for was a submission on the substantive merits, and I will submit to you, for the reasons that we've seen in both the Geoprosco case, but also the analysis of that by Mr. Justice Carr, that's where, with the greatest respect, the judge went wrong, because that is not part of the analysis. Had he instead approached it on the basis of correct test, then I submit that he would have been bound to find there was a submission.
Okay, that's your third point.
It is, my lord, yes.
So the rationale, effectively, is you can't be allowed to have a win-win situation.
Correct. My lord, just to finish my first submission, if we look at my learned friend's skeleton, it's written case, at paragraph 37, they refer, and you're looking for a reference, I'm sorry, in the key documents bundle, it's at page 49. They refer to the Tracker-Min case. That was one of the cases that we looked at a moment ago that applied, that said that Geoprosco was the correct position as a matter of common law, but things have now changed. It's now the 1982 Act. And they say, paragraph 37, Tracker-Min was a case involving the recognition and enforcement of a foreign judgment. So Mr. Justice Staunton was correct to say would have been governed by Geoprosco at common law. My lords, I submit that they're bound to accept that, namely that Geoprosco governed the recognition and enforcement of foreign judgment as a matter of English common law. What then remains between us is the point that I'm just about to go to, which is whether a different rule applies to anti-suit injunctions. And for reasons that I'm about to explain, I submit that can't possibly be. That's my second submission. If I can turn to that, please.
You haven't dealt with, as part of your first submission, whether it was appropriate for the Cayman Court of Appeal to decide not to follow Geoprosco.
So I'll probably end up dealing with these points, but I'll make it now, my lord.
As long as you deal with it at some stage.
Yeah. The point that I'll make about that is that when one looks at the Court of Appeal's findings, for example, if one turns to page 288 of the key documents bundle, the Court of Appeal choose not to apply Geoprosco for two reasons. And just before we look at that paragraph, the first reason is that they say that it doesn't apply, whilst it applies to the enforcement of foreign judgments and the assessment of whether a party has submitted for the assessment of for deciding whether a part deciding on enforcement of judgments, that principle does not apply when you're looking at anti-suit injunctions.
Well, that's their second reason. 296 is the synopsis of their points. And the first one is it's out of date, it's been overturned by Parliament in the United Kingdom, was always thought to be a bad decision. It's been criticised. Good reason not to follow it. But then they say, well, even if you might be followed in relation to recognition of foreign judgments, won't apply to anti-suit.
Yes, and my lords, the point that I just direct your attention to in that page is Roman 4, where, which is what I was then just going to come on to, which is the Court of Appeal's understanding of Geoprosco. They say there, the Court of Appeal itself in Geoprosco had recognised the tautology of its reasoning. Why should a party, merely by applying to a foreign court for a stay, on the basis that it ought not to exercise jurisdiction over the proceedings in question because of an exclusive jurisdiction arbitration clause, be regarded as having submitted to the jurisdiction for all purposes? And the paragraph I was just taking to a moment ago makes the same point, which is that the Court of Appeal's interpretation of Geoprosco was that it meant if one objects to jurisdiction, via a stay application or anything else, that is a submission to the jurisdiction. And that is not what Geoprosco decided. And we see, as the paragraph I was just taking my Lord Hambledon to was at page 288, making the same point, paragraph 101, second sentence, where the court was comparing the test in Williams and Glinsbank to Geoprosco and said, indeed, that formulation of the test seems the antithesis of the hard and fast rule from Geoprosco, where, as cited above, one sees that submission on the merits is deemed to have occurred from the very fact of the bringing of an application for a stay, or for that matter, a mere appearance to challenge or protest against jurisdiction before the foreign court. And with the greatest respect to the KEKA, that was not the effect of Henry and Geoprosco. And so, in my submission, the Court of Appeal misunderstood the effect of Henry and Geoprosco, and that led them into error. It led them to saying that can't be right, so we're not going to apply it. When actually, if that had been understood correctly, there's nothing objectionable in principle about the matters that are set out in Henry and Geoprosco. Well, that's my overarching first submission. If I could then turn to my second submission, which is that the same common law rule.
Just to be clear, if the correct interpretation of Henry and Geoprosco is that you can't challenge, the challenging on the grounds of foreign convenience is a submission to the jurisdiction, you would agree that that's wrong and should not be followed?
If the position in Geoprosco is that a forum non-convenience challenge would amount to a submission, that would be wrong, and that as has happened in England, but in many jurisdictions around the world, the correct place in which to address that, if there was to be thought to be necessary to be a change in the law, is by way of legislation. And that's why we've seen that in many jurisdictions around the world, but not in the Cayman Islands. Well, my second submission is that the same...
I'm so sorry, but
yeah, of course.
What you just said slightly confused me.
I'm sorry.
So I think in answer to my Lord's question, you said that insofar as Geoprosco includes a challenge on the grounds of foreign non-convenience as amounting to a submission to the jurisdiction, it is wrong. I said, yes, it's wrong. I took the question to be wrong as a matter of the common law, but then you said it would have to be corrected by legislation. But if it was wrong as a matter of the common law, it wouldn't need to be corrected.
Yeah, no, I accept that. So let me state my position. In my submission, the case of Henry and Geoprosco is not wrong. There's no part of it which is wrong. It properly interpreted makes it clear that whatever application one makes to the foreign court, if that is solely to do with protesting jurisdiction, that does not amount to a submission. And if that's whether that's done by way of forum non-convenience, whether it's done by way of an application for a stay.
But sorry, just on the reading of Geoprosco,
Yes.
I thought at page 2023 at D, court refers to the second and third grounds as amounting, and we know that the third was contesting jurisdiction on foreign non-convenience grounds, did amount to voluntary submission.
My Lord, yes. I mean, I think that must be there on the basis that it went beyond. It went beyond merely protesting jurisdiction.
Well, it does go beyond protesting jurisdiction, because protesting jurisdiction is to say you should set aside you have no jurisdiction over me, set aside service. But
Yes.
forum conveniens, the starting, as with an arbitration stay, the starting point is you do have jurisdiction. You shouldn't exercise it. And that's what everybody's taken Henry and Geoprosco to draw how distinction it's drawing. But you say it shouldn't be understood like that, or so far as it is, it's wrong, I think you're saying. Well, you have to say it, don't you? That the second sentence of paragraph 2 on that page is wrong.
I think, my Lord, if the court thought that Henry Geoprosco said something different to the submission that I'm making about how it should be interpreted, then I think it follows that.
No, I mean, yes, well, not what the court thought, but
I mean,
sorry, the paragraph that Lord
Yes.
Sales was referring
It's
to.
the
I
middle
think I haven't
paragraph
got it,
on
but I
page
think it's the second
2023.
sentence of the second paragraph. It goes on to say.
Yes. And I mean, surely they seem to be saying expressly there that the challenge to jurisdiction on grounds of foreign non-convenience constituted a submission to the jurisdiction.
My Lord, I must say, can I possibly deal with this point in reply because it's not something that because the focus has been on point 1, I haven't,
Right.
and this case doesn't involve a foreign non-convenience challenge. I haven't looked at that, but can I spend just
Yes,
10
all right.
minutes looking at that, and then
Yes,
I'll
of
come back to a better response.
And maybe Harris and Taylor will also need to deal with as to whether that, because they say it's indistinguishable from Harris and Taylor, so
I'll come back to you on the.
that's all part of the point.
I mean, of course, foreign non-convenience is not this case on the facts, but I do, of course, understand why your lordships are asking about it as a matter of principle, and so I'll come back to address it.
So I think you were moving to your second proposition.
I am.
There's no good distinction between an anti-suit injunction and enforcement
Lord,
in
I am.
terms of submission.
Yes. So Rubin is the starting point, which is a case called Rubin. It's at page 2252 of the main bundle. This was a case about enforcement of judgments, one US and one Australian in England, and it was the judgment of Lord Collins. We pick this up, please, at page 2266. At paragraph 7, the court considered the dicey rule, first of all, that is Rule 36, and set that out. The relevant part for our purposes, the top of the next page. Third case, the person against whom the judgment was given submitted to the jurisdiction of that court by voluntarily appearing in the proceedings. And then if we go to page 2298, court then deals with that submission question. There's all sorts of other things going on in this case, but just jumping to the submission point. Paragraph 156, dicey rule applies. Judgments in issue will be enforceable in England if the judgment debtor submitted to the jurisdiction of a foreign court. And then at 159, so the general rule in the ordinary case in England is that the party alleged to have submitted to the jurisdiction of the English court must have taken some step which is only necessary or only useful if an objection to jurisdiction has been actually waived, or if the objection has never been entertained at all. And for that, the court cited Williams and Glynn's Bank. That's the case that I mentioned, which is the sort of twin track on this particular area of law.
Would you object to that statement of principle?
No, or certainly not in the sense of, on the facts of this case, I submit that we satisfy both. In actual fact, what I'll come on to say is that that principle and Geoprosco can be reconciled by reference to the 3 points that I made earlier. That there's no suggestion, for example, that simply objecting to jurisdiction is a basis on which there can be a submission. Likewise, there's no requirement for the substantive merits before the court. The two principles are not impossible to reconcile. But then at para 160, which is really the point I'm making now, the court said the same general rule has been adopted to determine whether there has been a submission to the jurisdiction of a foreign court for the purposes of the rule that a foreign judgment will be enforced on the basis that the judgment debtor has submitted to the jurisdiction of the foreign court. So, para 159, that's the rule that applies where one is looking at submission within England. Para 160, that same rule has been adopted to determine enforcement in respect of a foreign jurisdiction, and not only in respect of enforcement, but as we see from the last of the cases that are cited here, Industrial Maritime Carriers, Eastern Trader, 1996, brackets, a case involving the question whether the party seeking an anti-suit injunction in support of an English arbitration clause had waived the agreement by submitting to the jurisdiction of the foreign court. My Lord, 2 points emerge from that. The first is that there are two tracks of case law, but as I just said a moment ago, they can be reconciled. Geoprosco was not cited in Rubin, either in the judgment or in arguments. Instead, the court applied this parallel line of cases, namely Williams and Glinsbank. Williams and Glinsbank does not cite Geoprosco either, nor does it cite Harris, nor any of those other authorities going back to the 1800s. And if you'd like a reference for that, that's page 2552, showing the cases cited in Williams and Glinsbank. My Lords, as a result, there have been two tracks of case law that have developed. On the facts of the present case, either test is good enough. On either test, you're not looking for a submission on the merits. And properly understood, as I say, there's no conflict between those two lines because, number one, stay application on grounds solely of objecting to jurisdiction would not be sufficient. But taken in the round, it may be that such an application, if may be a submission to the jurisdiction, if, for example, it asks the foreign court to determine an issue between the parties, and there's no requirement of having contested the substantive merits. That's the first point that emerges from Rubin. The second point that emerges from Rubin is that that submission rule applies across the board. Same general rule on submission applies whether that is in relation to enforcement of a judgment or an anti-suit. Well, there's that final case that was cited, the Eastern Trader, we find at page 2133. That was an anti-suit injunction case, as Lord Collins identified. And if we just go, please, straight to page 2135. This is a judgment of Mr. Justice Ricks. We see in the first column on the left, about halfway down that paragraph, in the proceedings before me, the court is asked by the plaintiff shipowner for a declaration. Proceedings commenced by the defendant charter in Algeria are in respect of disputes which the defendant has agreed to arbitrate in London. Plaintiff therefore asked the court for an injunction, both permanent and in the meantime interlocutory, to prevent the defendant from continuing its proceedings in Algeria, cf. The Angelic Grace, which of course is the key anti-suit injunction case. And then if we go to the second column, please, the second paragraph, the court said, the essential question before me, which arises on the defendant's challenge to the court's jurisdiction under its summons, Order 12, Rule 8, is whether the plaintiff can show a serious issue to be tried. It's entitled to the relief claimed in these proceedings in light of what is alleged to be submission to the jurisdiction of the Algerian court. That involves the question whether there was such a submission or whether there is a serious issue to be tried. There was not. These questions arise because of the provisions of the 1982 Act. So by this time, of course, it's no longer the common law. It's the 1982 Act, but absolutely clear that the same test applies whether one is considering enforcement of a foreign judgment or an anti-suit injunction. My Lords, SPV 21 accepts, as I submit they must in the light of that case, that Rubin provided for a single common law test across all situations regarding submission to a foreign jurisdiction. We see that in their written case at paragraph 53. Which is in the key documents bundle, page 54. Say, so paragraph 53, it's page 54 of the key documents bundle. They say there, accordingly, in Rubin, the Supreme Court held that the general position on submission to the jurisdiction in English law across cases, including those where anti-suit relief was an issue, was as per the Williams and Glinsbank case. So, my Lord, they accept it's the same test, the single law, common law test across all situations. The point that they now make is that it should be the Williams and Glinsbank test, not Geoprosco. And they make that point at paragraph 55. Where they say, in English law, the approach to the question of submission to the jurisdiction would have been that set out in the Williams and Glinsbank and Rubin, namely whether on all facts the party in question took a step which was only necessary or if any objection to jurisdiction had been waived. My Lords, that does not mean that Geoprosco is to be ignored. As Mrs. Justice Carr said, Geoprosco is part of the common law and is to be given effect.
I understand the way your submission is being developed. It sounds as though Geoprosco is all a complete waste of time, because we could just start with the Williams and Glynn test. You accept, do you?
Lords, on these facts, I accept that gets us through. So on these facts,
But I didn't understand you to be arguing that the law is different from that.
well, there of course are two statements of the principle, and the way that one reads them, they use different words. But in terms of the way they operate, I mean, actually, when one looks at the Williams and Glinsbank test, the way that it's expressed actually is quite confusing. I'm not sure it's the best expression of the test, and I'm not sure it's the one that this court will necessarily want to say, well, this is the test. But in terms of the principles that I outlined earlier as to what Geoprosco means, I submit that the Williams test means no different, and they can be aligned in that way. And of course, it makes sense that the same rule applies across the board when considering submission to the jurisdiction of a foreign court, whether that's considering that question during the pendency of the foreign proceedings, i.e. when you're concerned with whether to order an anti-suit injunction or not, or after the foreign proceedings have ended, when considering enforcement and recognition of a foreign judgment. It would make no sense to have different tests at those stages. And my Lords, there's no authority which shows that you have different tests. Rubin says the same test applies, whichever the stage. And my Lords, where that leads to me in terms of this appeal is, with the greatest respect, the Court of Appeal were wrong to find that Geoprosco applies to one situation, namely enforcement and registration of judgments, but not the other. And we see their conclusion on that at page 102. Sorry, paragraph 102, page 289 of the key bundle. So that's my second submission. It can't be right that different tests apply when considering the position during foreign proceedings versus when they have ended. My Lords, that takes me to my third submission, which is that the courts below applied the wrong test. And had they correctly applied the Geoprosco, or for that matter, the reconciled Geoprosco and Williams and Glinsbank test, they should have held that there had been a submission to the jurisdiction in Pakistan. My Lords, there were two applications made by SPV 21 in the Pakistan proceedings. The first of those we see in the main bundle at page 1338. It starts at 1337. This is headed an application filed on behalf of defendant number 1 under section 4 of the Recognition and Enforcement of Arbitral Agreements and Foreign Arbitral Awards Act. That's the Pakistan Act. Para 1 says that this case should have been referred for foreign arbitration. Just to note, it doesn't really matter, but just to note that that was incorrect. There wasn't actually an arbitration clause, but it doesn't really matter for the argument we're dealing with. In other words, just to, in terms of...
Was that just a mistake? Because they got the wrong version of the SHA?
I think so. It was a mistake, but I think so.
And nothing has turned on that throughout these proceedings?
No, I don't understand it.
Because the arguments would all have been the same if they'd referred to the current version of Clause 25 and its exclusive jurisdiction for England and Wales.
Exactly. So just, this is page 1337, just to make sure that your lordships are all with me. Then at paragraph 2 to 5 onwards, your lordships just glance at those. It may be that there's time to read them in a little more detail later. One can see that what is being argued here is the case. So, for example, in the middle of paragraph 2, they say it is submitted that both the grounds, that is the grounds on which the suit has been filed in Pakistan, are incorrect and misconceived, as no change in shareholding of defendant number 4 is being made. Defendant number 4 is a company known as KEL. It is the company which owns a very valuable asset in Pakistan and is really what the parties are in dispute about. In other words, that was hitting right at the heart of the parties' dispute. And then continues to paragraph 3. Submissions, for example, at the end of the page. As a result, the 2 individuals who'd been nominated by defendant number 3 upon the request of defendant number 1 to be induced as directors have been put on hold.
The question is not what they're saying here, it's a question of what they're asking for, isn't it? I mean,
It is exactly.
Yeah,
Yep.
so...
Yep. But this all goes to, and we'll see, because there's the two applications that go together, both issued on the same day, and what's in here goes to both. Paragraph 4, essential background. Defendant number 3 is a holding company. Defendant number 4. Paragraph 5. Defendant number 3 can nominate the following directors. There's an explanatory chart which was attached, chart number 1, explaining that. And then at paragraph 6, final sentence, they say the only case where such approvals would be required, that is approvals to change the shareholding, required was where there's a change of shareholding of defendant number 3 itself, which is the holding company of defendant number 4. Present, no such change has occurred or being affected, and proportionate shareholdings of plaintiffs and defendant number 1 in defendant number 3 remains intact. My lords, that's exactly the substantive dispute.
But what these amount to were issues before the judge, and he decided that they only went to jurisdiction. Go to paragraph 201, 202, 217.
My lord, he did.
He does.
And he
That's
did.
a matter for him. It's not a matter for us.
Well, my lord, it's the point that I'm going to mention, I haven't shown you this, is that the test that actually he applied was to look to see if the substantive merits had been argued. And that was the wrong test to apply. So if we look at Mr. Justice Segal's judgment, paragraph 204, for example, that is page 217. Yeah. The judge said the Order 39 Rule 4 jurisdiction. We haven't got to that application yet. There are 2 applications. Order 39 Rule 4.1 is the one that it's not simply the stay. On top of that, they asked for relief, and they did that by way of a variation. They're asking for a variation to the order that had been made. So then, at the end of that page, 217, in this case, it appears to me, having regard to the drafting in terms of the order, 39 application and all expert evidence, that the applicant was using the Order 39 application to challenge the granting of the injunction, and the references to the Pakistan court permitting the appointment of the applicant's nominees as KEL directors to proceed should be seen as relief that would flow as a consequence of the application being successful and of a stay being granted, and not as substantive relief sought to enforce the applicant's right under the SHA to appoint the KEL directors. And then he continued.
So you can't go behind that.
Well, the point I'm going behind is that the law that what the judge was looking for, and we see a few references to this, I'll show you some others, was whether the substantive relief was being sought in the Pakistan court. And that, I respectfully submit, is inconsistent, directly inconsistent with Geoprosco, Cayman Geoprosco, which makes clear, and Mr. Justice Carr did as well in her analysis of it, that what is not required is that, and that therefore, I'm not seeking to challenge the underlying facts. The application that I'm going to show you in a minute say what they say. I'm not suggesting, not going behind those, but having applied the wrong test, if one simply just looks at those documents and says, right, I don't need to look for an application for substantive relief. I'm looking at whether there is a stay application, and then the defendant has asked me to deal with an issue. And that's
Deal with an issue, what does that mean?
well, the issue that they know, what we'll see from the applications, the issue is they say, we want you to order that we are entitled to appoint the following directors to the board. And that was and remains a central issue of disputes. And one can see what they were doing. It was just an opportunistic attempt to say, oh, well, this is now before the Pakistan court. If I get this order from the Pakistan court, fantastic, I've achieved what I wanted. The problem for them is, if you do that, you've submitted, and you can't then say, well, I haven't got it there, I'm going to try somewhere else. That's exactly, I respectfully submit, the point of the law that we're dealing with.
But, I mean, looking at that sentence in paragraph 204, the judge characterises that as a consequence of the application for a stay being successful. So he is characterising it as they're asking for a stay because it's the wrong, the dispute should be pursued in a different jurisdiction. Because of the ex parte application by your clients, the Pakistan court has intervened by positively making an order, but it should unravel the effects of that order to reflect the stay that ought to have been granted. And in doing that, one way it can do that is by making these changes to the order, simply to unravel what it shouldn't have done.
And what we'll see, as I'll show you that application just in a moment, what they say is, what we want you to do is to allow the stay, but only after you've amended the order to allow us to appoint the directors. In other words, what they wanted to happen was, order that we can appoint these directors, then bring the shutters down.
But that is to restore the position to where it should have been if no application for an injunction had been made in the first place by your clients, because they should have litigated elsewhere.
Well, that's right, I agree with that, but with one clarification, which is there is a difference between that, because they have, I don't know if it's in a pejorative way, but they have never felt brave enough to do that, actually, and to have an order. What they really wanted was an order from a court that said they could do that. And there is a difference between, okay, well, there's no order at all, and an order from the Pakistan court which says you're entitled to appoint these directors. That's what they were after, I respectfully submit.
You're going back into what was an evidential issue before the judge, seems to me.
My Lord, that is simply on the basis of the face of the document. I'm not.
No, but he's looked at what the document says. regards the expert evidence, and this is his conclusion.
It is, but it's, as I respectfully submit, on the basis of an incorrect understanding of the law. And his conclusion there is, what was not being sought was substantive relief. If your lordships were to decide that that's not part of the test, then the judge applied the wrong law, and I would submit that that means the facts, as they are stated, I'm not seeking to challenge the facts or go behind them, have to be then assessed in the light of the correct legal test, i.e. you're not looking for a substantive, an argument on the substantive merits. Well, I'm conscious I've only got 5 minutes.
Yes, yeah.
Can I just whiz through the final points? Let me go back to the applications, because I think it's just important we just see those. If we just go back, please, to page 1339. Actually, 1338, I think. About where we got to. Paragraph 7, they said that, as stated above, there's been no change of shareholding in defendant number 3. Whilst there has been from time to time, for many years, in the ordinary course of business, consistent with past practice, changes in shareholdings entities above both defendants number 1 and 3, including the investment fund, which is explained in accompanying chart 2 attached herewith. So in other words, they then put another chart before the court, which we'll look at in a second. However, this has no bearing on the shareholding of plaintiffs and defendants number 1 in defendant number 3, which remains intact, and there's no change to the rights, entitlements, etc. My lord, all of that was being said to persuade the Pakistan court to modify the injunction to allow the appointment of directors. We'll see that in just a moment. And this was an attempt to achieve that relief via a modification to the injunction. And in my submission, that is sufficient as a matter of law. One does not need to be seeking substantive relief as the judge was looking for. Just for completeness on that chart is at 133.
Is there any finding made by the judge that you rely upon, as opposed to asking us to interpret the underlying documents?
My lord, in terms of those facts, I suppose the facts that I'm relying on are the existence of...
Facts as found.
Yeah, are the existence of the 2 applications that were made that the judge describes, namely the one we're looking at and the next application, the Order 39 application. He sets out, I'll have to find you the exact reference, but he sets out what those, earlier on in the judgment, what those contain. And all I am relying on is what those documents contain. I'm not seeking to, there was no challenge to the facts about those. They are what they are. But I understand...
There was a great deal of challenge in the expert evidence as to what they amounted to.
Correct.
And he's made findings about that. You can't go behind those findings.
I accept that. But I'm not seeking to go behind the finding as to what they amount to, save that, to the extent the judge said they were not seeking substantive relief, submit that wasn't an application of the correct legal test, and that when one looks at them in the correct light, they were.
Right. In that case, you're trying to go behind a fact finding he's made. You can't do that. You didn't challenge him in the Court of Appeal either.
Well, I suppose that my only answer to that, my lord, is that if your lordships find that the judge was wrong to be look for an argument on the basis of the substantive rights, and finds that was wrong, that the only way to then assess what the correct position is to look at those facts in light of the correct law and the content of the documents themselves. There's no dispute about it. But my lord, I take your point, and I want to be clear, I'm not seeking to go behind any findings of fact. I'm just really showing you the documents because it's just an easiest way to do it. But can I just for completeness, since I'm on it, just show you the final document, which is the the second of the two applications, which is at page 1333, which said we're making an application that there should be a stay, which is the application we just looked at, and in addition, the end of paragraph 3, we'd like it to be stayed, but after recalling or vacating the ad interim order. That says vacating. What actually happens then at paragraph 4 is that they say what they're after by way of variation, and at paragraph 5 you'll see they say that it is submitted in view of the above, that the ad interim order may be recalled / modified. Sorry, that's paragraph 6. So they're actually asking for modification, thus enabling the defendant number 1 and 3 to exercise its lawful right of nominating the proposed replacements. And at paragraph 7, if that's not done, she'll be seriously prejudiced. In other words, what was being said was, please recall, modify the order, do that before you stay, and then stay. Please vary the injunction by finding we have the lawful right to nominate replacements on the board. And my lords, that would have been a significant win for them if the Pakistan court had gone for it. I submit it's obvious what they were trying to do there. As a matter of fact, it would give them what they wanted. And I also finally submit that that went beyond simply saying to the Pakistan court, we object to your jurisdiction. It was a submission to the jurisdiction of the Pakistan court to determine that issue. Can they appoint directors? And that issue was and is one of the central issues in the case.
So isn't that substance of the case? Isn't that the merits of the case?
Well, they were doing it, though, by way of, effectively, a challenge to the injunction, which I think is the distinction that's being drawn, which is, you don't need to have a defence, you don't need to put forward the substantive merits, but if actually you're putting an issue before the judge in Pakistan to be determined, which they were, there was then a reply from us to these applications, of course. This was all going to be heard on its merits in front of the Pakistan court. That is submitting to the jurisdiction on the basis of the tests that I submit to your lordships.
Now, Mr. Quirk, you're at the limit of your time, but you can go on, but it'll come out of your reply time if you want.
Lords, I am finished. Thank you very much. I'm sorry I had to canter through that final.
All right. Thank you very much. So the board will break there for lunch. We will resume at 2:15.